I will now call 123100, State v. Buchanan.
Didn't plan out just how big my binder would be. Good morning, Emily Brandt of the Appellate Defender Office here today on behalf of Mr. Ronald Buchanan, the appellant, present and ready for argument. I would request 3 minutes for a rebuttal.
3 minutes is granted.
Although we are before you today on 3 issues, we intend to primarily focus our oral argument on the issue of first impression before this court. What is the unit of prosecution for arson? And are Mr. Buchanan's 6 convictions for aggravated arson multiplicitous? In the early morning hours of May 14th, 2018, a single fire occurred at the Spring Hill apartment complex. All the occupants of the building were able to evacuate, and that single fire resulted in Mr. Buchanan being convicted of 6 counts of aggravated arson, 3 counts of attempted first-degree murder, and 1 count of cruelty to animals. The double jeopardy clause of the Fifth Amendment and Section 10 of the Kansas Constitution protect against multiplicitous convictions. The test for whether a conviction is multiplicitous is found in State v. Schoonover. The parties are in agreement that the first 2 elements of that test are met. Here we have unitary conduct. There was 1 single incendiary fire, and the 6 convictions arose from the same aggravated arson statute. Therefore, the only inquiry before the court today is what is the unit of prosecution for arson? And the key to determining the allowable unit of prosecution under a statute is legislative intent. This turns us to the plain language of the arson statute. Looking throughout the arson statute, we can see that arson is by setting a fire or use of explosive devices, damaging a building or property. Using this plain language, it is our opinion that there are at least 3 units of prosecution intended by the legislature here. It could be a building or property, how many buildings or properties were damaged by said fire, fire or explosive, the number of fire set or explosive devices used, or another person, how many people were affected by the fire. And even in the state's briefing, they argued that there could be at least 2 units of prosecution, a building or property, the numbers of buildings or properties damaged, or looking specifically at the aggravated arson portion of the statute, a human being, so the number of people affected. Cleaning up the statute, the Court of Appeals reasoned that the unit of prosecution must be a building or property, and that property must include an apartment located within a larger building complex, because an apartment is a dwelling, which is property. However, based on our position and the state's original position, we could end the inquiry here because both sides agree that there are multiple potential intended units of prosecution under the arson statute. And if it's not clear and unambiguous what the unit of prosecution is, that triggers the rule of lenity. And you would have to find in favor of Mr. Buchanan and vacate 5 of his 6 convictions for aggravated arson. If, however, you believe that the plain language of the arson statute does clearly define a unit of prosecution, we would think that the plain language does not support the position that a building or property necessarily includes a dwelling, because it's a lot of work to get the plain language when the point of a criminal statute is to provide a person of ordinary intelligence with fair notice that certain conduct is prohibited by law. If a person of
Don't we have to look at more words of the statute than what you've cited to us, though? Because the closing portion of 5812A1A is any building or property which, and this is the language I want to focus on, is a dwelling in which another person has any interest without the consent of such other person. Doesn't that really narrow the focus of and give a strong hint of legislative intent that what we're looking at would be the properties where there is an interest, and here we have the different members who have an interest in the property?
Thank you, Your Honor. We would say that no. So when you're looking at the arson statute, certainly under A1, there are 4 subsections. 2 are to a dwelling, 2 not to a dwelling. Then we have 2 and 3, 1 to a dwelling, 1 not to a dwelling. And then we have the aggravated arson portion. And under that, we have the severity levels for all of those subsections. So to us, it doesn't actually narrow the focus of what the unit of prosecution is based on what subsection of arson a person is charged under. What that subsection does is changes the severity level of the crime that a person could be penalized for. When you're looking at the arson statute, I don't think that it's a fair interpretation that a person of ordinary intelligence is supposed to look at every single subsection to determine what the unit of prosecution for that subsection would be. It's our position that the unit of prosecution for arson is the same. No matter if you're charged under A1A, A1B, A1C, A1D, or B1 as aggravated arson. And so it doesn't actually narrow the focus by picking a subsection under A1. We would also submit to the court that the state didn't actually charge it under A1A. The jury instructions did not mention that the apartment unit was a dwelling. Nobody found that it was a dwelling. And so we think that there is, in this case, specifically no basis for narrowing it to subsection A1A and a dwelling.
How was the jury instructed? And does
If I
that
may
matter?
I think that it does matter. If this court wants to make a separate unit of prosecution for every subsection of the arson statute, then it would matter what the jury was instructed and also what the state charged. Here, the jury instructions say to, this is just jury instruction number 18, picked out of a hat. They all kind of say the same thing. The defendant is charged with aggravated arson, substantial risk. The defendant pleads not guilty. To establish this charge, each of the following claims must be proved. The defendant committed arson knowingly by means of fire, damaging a property. At the time, there was a human being in the property. The fire resulted in substantial risk to bodily harm, and this act occurred on or about May 14th, 2018 in Johnson County.
And was the property separately defined for each of the 6 charges?
Yes, it was. Separate. Some of them say by means of fire, damaging a property, specifically apartment 2203.
Okay. So
But
by the instructions, at least, the way the state argued its case to the jury was each apartment is a separate property under the statute.
or building. But yes, it would seem that they rely on property. It would also seem that the Court of Appeals relied on property and defined that property must include a dwelling. We also think that this can't be the legislative intent. Although the Court of Appeals looked at the definitions in KSA 215111K for dwelling, a dwelling is a building or portion thereof. And so the Court of Appeals has attached that version, a portion thereof, to include property. But if property is a portion of a building, we think that that renders a bit superfluous what building is. If building can be a property, or if building can be a dwelling, why does property need to be a dwelling? And if both are always dwellings, what is the point of in 2 subsections explicitly stating a severity level for setting fire to dwellings, and explicitly in 2 provisions setting fires to what are not dwellings? We think in this specific statute, the legislature meant something other than a building or a dwelling when they said or property. They were thinking of a car or some other personal property that somebody could set fire to or explode. We also think that for your consideration that this court should consider that what the unit of prosecution under arson actually is fire or explosive. Consider the theft statute, which is 5801, which is also a property crime like arson. In State v. Hood, this court held that the conduct the legislature intended to prohibit was gaining unlawful authorization over property. And thus the unit of prosecution in theft cases is theft is the act of unlawfully taking property. In Hood, a patron of a restaurant went in, bought a drink, noticed there was a money bag floating around and thought, oh, I'll hang out, see if I can snag that money bag. The restaurant closes, the owner, manager, operator is cleaning up. She sets her purse on the counter and she sets the money bag on the counter and she goes to take out the trash. When she exits the building, Hood picks up the money bag and he picks up the purse and he leaves. He's originally convicted of 2 counts of theft. And one of those is overturned by this court as multiplicitous because what matters is the taking. He could have taken 5 things, or he could have taken something that was hers and something that was the bank's, the money bag and the money. That didn't matter. It's not 2 people that had stuff taken from them, and it's not 2 items that are taken. It's just the singular act of taking. Analogizing that to the arson statute, the prohibited conduct is setting fire or exploding any building or property. So thus the UOP for arson should be the act of setting fire or using an explosive device.
What if, how would that work in a scenario where, let's say we're not dealing with apartments, we're just dealing with single family homes. One fire is set to one single family home, and because there are high winds or whatever, it burns down the whole neighborhood.
We would submit that that's still one arson.
That is one arson, and the legislature did not intend for that person to be able to be prosecuted for 10 different home burnings.
Right, because the unit of prosecution in our mind should be the number of the act of setting the fire or detonating some explosive device. And certainly there are other ways in which people can be charged for damaging property. For example, if you look at the criminal damage to property statute, which is 5813, it covers all damage to property by means other than fire or explosive. Further suggesting that the unit of prosecution for arson must be this act of setting a fire or using an explosive device, because any other means of damaging property would be covered under the unit of prosecution in a different statute. There was one fire set on May 14th, 2018. One building was destroyed as a result. It may have included multiple units within it, but one building. So whether based on the plain language of the arson statute, the unit of prosecution is building or property or fire explosive, we submit that Mr. Buchanan's convictions for aggravated arson are multiplicitous. But if the unit of prosecution can't be determined based on the plain language of the statute, then the statute is vague, which triggers a rule of lenity. So this court must vacate under either theory 5 of Mr. Buchanan's aggravated arson convictions and remand for resentencing. I see that I'm out of time, but I will stand for any questions.
Under your construction, if I may ask one question, Chief. If an individual sets fire to just a single family home, and it doesn't do the extent of damage that the perpetrator intended, lights a second fire, which accomplishes the objective, then as under your interpretation of the statute, that then would support 2 separate charges of arson.
We believe yes, because then we have 2 fresh impulses. You said the first fire didn't work. You said a second fire, a fresh impulse.
It's the focus on the actus reus.
Yes.
Thank you.
Does it, looking back to the common law of arson, have any role in this, and recognizing that at common law, the focus really was upon habitation or occupation? And assuming that the legislature was just codifying that common law, can we look there, and does that help?
Thank you, Your Honor. I don't think that it helps in this situation because the legislature has so delineated what arson is in the state of Kansas. We now have, again, arson that is to a dwelling, not to a dwelling. We have arson that involves controlled substances. And then we have aggravated arsons, which I think maybe does go a little bit to the root of arson, and this fact that it's bad to burn down buildings that people are in. But I don't think that that necessarily changes the analysis, because the mere fact that a person is in the building is really a strict liability crime. A person is either in a building when you set it on fire or they're not. And secondly, it would probably lead to absurd results if whether or not there was a person in the building affected the unit of prosecution for arson. In this case, if you did the unit of prosecution for every person affected, Mr. Buchanan could have walked away with 18 counts of aggravated arson. Thank you.
Thank you, Madam Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the state of Kansas, the appellee in this case. Mr. Buchanan's multiple counts of aggravated arson, convictions of aggravated arson are justified and proper here because the actions that he undertook damaged the dwellings, the properties held by multiple different individuals, properties with different individual ownership and privacy interests, locked doors, and so on. And like our courts have said, when there are multiple private residences or private places, those can support multiple counts of burglary, for instance. Nothing is different here. And
So
what
it's
I'd
the
like,
interest that's important.
it is.
What about, I'll give you a totally separate hypothetical. Someone burns down my closet and I happen to have 5 dress shirts in there. I had an interest in all 5 of those. They're all property. Is that 5 acts of arson?
I don't believe as though it's 5 acts of arson necessarily, because when you look at the statute, what sets it apart from theft or criminal damage or other property crimes is the person element in aggravated arson. What Mr. Buchanan was convicted of was aggravated arson.
Yeah, but aggravated arson is piggybacked on the arson statute.
Correct.
So you have to have arson first,
True.
and then you get an added element.
Yes.
So, I mean, you could also imagine a person having been in my closet. I don't know why they would be, but I mean, that hypothetical still holds together. I don't understand why, if the unit of prosecution is property in which another person has an interest, why doesn't the burning of each item of property create a separate crime?
Because when you look at the statute, I believe the use of property in the statute doesn't envision the individual pieces of
Why not?
tangible
I
property.
guess is my question.
I guess going back to the Chief Justice's question, when we look at the roots of arson, what it talks about is things like dwellings or buildings or portions thereof. And that's what's going on here. This is, when I look through other crimes.
So I'm sorry to interrupt, but just pursuing the line of questioning a little bit further. If this person took my 5 dress shirts outside and just burned them, would that be arson?
I don't believe it would be.
Even though the statute just says by means of fire, damaging any property in which another person has an interest.
Well, I believe here we set it apart because it's a building, and that's the prong of the arson statute that we're talking about, is the building, the apartment complex that was burned. Whether or not burning your 5 shirts would support 5 counts or not, I cannot say at this point. This is an issue of first impression for this court, as opposing counsel opened with, which makes it an interesting one. And this court can find guidance in how it has addressed multiplicity issues in other statutes. And if you look through the Criminal Code of Kansas, they're separated by person and non-person felonies or misdemeanors. The state looked through, in looking through as many person felony statutes as I could that have been addressed for unit of prosecution analyses by this court. The only one I could find that did not envision multiple counts for multiple victims was the criminal threat statute that was addressed not that long ago by this court, in which the court said criminal threat, 1 threat communicated to a crowd will still only support 1 count of criminal threat, not 1 count for every individual that was threatened. That statute, though, stands apart in that what is criminalized in criminal threat is a threat communicated to another. And this court said, when you look at the meaning of another, it can be a person or persons. It can be single or multiple. And so the analysis was that statute was written by the legislature in a manner in which it's the communication of the threat, the single act that supports just one count. But when you look at the arson statute, we don't have that same ambiguity present in which the legislature criminalized actions that impacted a person or multiple people.
Well, I'm sorry to interrupt, but doesn't any building or property do just that? Any, the definition could refer to the collective, or it could be each. And isn't that the same analogy that you've just described with the criminal threat statute?
I don't think that's what the any means respectfully within the statute. I believe it means any property, as in we're not going to narrow it down between a trailer or a camper or a boat or a vehicle or a house or a condominium. And so within this statute, though, it is a person felony, like all other person felonies. This statute speaks of damage or a threat to an individual person. And when that occurs, and when you have caused that damage to an individual person's interest or threatened their life, in this case, that supports multiple counts of aggravated arson. That's been the state's position all along, that the aggravated arson statute in particular, although it is a subset of arson, as Justice Stegall mentions, what we're operating under here is the unit of prosecution for aggravated arson. That's the statute under which Mr. Buchanan was convicted. And the unit of prosecution involves either the different properties in which individuals had an interest, and there were multiple properties that different people had an interest in, or the number of individuals that were present, just like in other person felony
Counsel,
crimes.
let me ask another, it's another hypothetical, but thinking about potential consequences of the ruling you're asking us to make.
Yes.
If we rule in your favor and find there are multiple units of prosecution in an apartment building, how would that impact a future scenario in which an apartment building is empty except for one apartment on, let's say, the far west end of the building, and an individual lights a fire on the far east end of the building, and it never touches the apartment that the person lives in? Is that aggravated arson?
I
or
don't,
not?
I don't believe it would be then unless
Okay, so to be consistent, you're saying you're breaking that building up into multiple different dwellings, and if the fire doesn't touch the dwelling in which the person exists, you would say that a prosecutor could not come and bring an ag arson charge in that scenario.
In that scenario, I guess you could break it down two ways. You could either say the individual could be charged with multiple counts of arson for the different units that did catch fire.
But you can imagine a
Or-
prosecutor saying, look, this is a building.
Right,
There was a person in the building.
right.
That's aggravated arson.
Then that would support one count of aggravated arson for the envelope of the entire building, but not multiple counts of arson and then one count of aggravated arson on the end for the unit that wasn't touched. That would be my consistent argument, keeping consistent with the argument I'm making today. I believe it would be justified to either charge multiple counts of straight arson for the empty units if they burned, or not along with, but or a single count of aggravated arson for the envelope of the entire building that contained an individual. Here, multiple individuals had an interest in that building, as the state has maintained all along. That's why it was charged the way that it was. And that's why the instructions that were offered to the jury that delineated the different units separated out the counts that way. Individual property interest holders within that building that were impacted. The gravamen of aggravated arson is the presence of that other person. It's not a property crime, it's a person crime. And that's what distinguishes it from theft or from burglary. Other multiplicity analyses that have been conducted by this court that found the individual act, the single act, can only support one count of theft or burglary in that instance. But multiple counts of aggravated burglary are justified if an individual breaks into multiple apartments within one building or multiple rooms within one hospital. That can support multiple counts of aggravated burglary. The same should hold true here for the burning of a building in which multiple people had an interest.
Opposing counsel, I thought, mentioned that there was no finding that this was a dwelling. Is that an issue in this case? And if so, was a finding made?
It was not raised as an issue in this case. I believe opposing counsel did correctly recite what the jury was instructed upon and the complaint language that was present in this case, but I don't believe as though it's pertinent to the analysis of this court in determining whether or not multiple properties were impacted for the multiplicity analysis. Mr. Buchanan never raised any instructional issues or instructional errors or concerns about the complaint below or to this court.
Your opposing counsel criticized, as I took it, looking at the definition sections as the Court of Appeals did. Have a response to that? I mean, that seem like a logical place for us to look to determine legislative intent of what they meant upon a building or property?
I absolutely believe it's so. It's a relevant place to look. And it's relevant because that's what reviewing courts have done in other multiplicity analyses. The statute is the information that is available to the public. To the extent that opposing counsel is arguing the statute couldn't be interpreted by the public or by somebody that would be impacted by this or charged under these statutes. These definitions are part of the law. They are published. They're available to everyone who seeks to further understand the aggravated arson statute. And the terms that the legislature chose to use within this statute is another person in the singular, or in aggravated arson, for instance, committed upon a building or property in which there is a human being. If the legislature only wanted to criminalize and justify a unit of prosecution being one for the entirety of the building of an apartment complex, they didn't need to put or property in the statute, but they chose to do so. They could have just left it at aggravated arson, instead of in aggravated arson committed upon a building or property in which there is a human being. They could have said committed upon a building in which there was some number of human beings. If that was the language that was chosen, they would have a better case that only one count could be justified under the aggravated arson statute for a building containing multiple properties and multiple people. But the legislature didn't write it that way. That's the way they wrote criminal threat, for instance, when they spoke about a threat communicated to another, because just another can be defined as an individual person or multiple people under the statute. But when we look at the language used by the legislature in the arson statute, it is upon a building or property. So there must be some significance to the legislature choosing to include both of those terms and to include the next clause in which there is a human being, not any number of people, for instance. So the state maintains that this case was properly charged and the convictions should be affirmed based upon the number of properties that individuals held an interest. The state could have charged it as 18 counts of aggravated arson if it was arguing the number of people who were present in the building. But that's not the case here today, because if you look at the complaint and the instructions that were offered to the jury, it was the number of apartment units in which an individual was present.
So the state has an alternative to charge it, whether there's an individual interest or the number of people in the building.
That is the second argument the state makes in the multiplicity analysis. We've maintained that position at the Court of Appeals and here. That wasn't how the Court of Appeals resolved the case. And so we're just asking that.
But under your theory, if there was 150 people in that building, could have been 150. If there was an event going on in that building, it could have been 1,000.
Yes, absolutely. Because the gravamen of aggravated arson is the presence of that person. Now, to the extent that the argument is made that leads to absurd results, it's not an absurd result to convict somebody of multiple counts when they burn down a building in which there are multiple people. If there were multiple people inside, they could have been convicted of multiple counts of murder. And so if they had died, for instance.
Understand, that's a different statute. We're just talking about the one act of setting a fire.
Right.
Result in 1,000 convictions.
It could. If it killed 1,000 people, it could support 1,000 counts of murder.
I understand that.
Right.
That's a different stat, but
it is a different statute, but for the same reason.
Were all the apartment units destroyed in this fire?
The
Or at least
bill,
burned?
yes, that all of the 6 units for which he was convicted of suffered.
Were there
severe
other
damage.
units that were also burned?
I believe there may have been one or two
do you
that
know
had
why?
nobody inside.
Do you know why they weren't charged?
I believe it may have, it's not in the record as to what the analysis was by the state, but it's not uncommon when looking at a case like this that carries 3 counts of attempted premeditated murder and multiple counts of aggravated arson, that we're going to be topped out by the sentencing.
But I
court.
presume your position would be they could have been charged.
Absolutely. If empty units within that building were damaged by the fire, absolutely.
What if one person rents out an entire apartment complex? That only one charge?
It would seemingly be one because you have one person with an interest, with a property interest there, in which another person has an interest, is the language that's used by the statute. To the same end, I believe in the state of Kansas, under the arson statute, I don't believe it would be a crime for you to burn down your own home because you're the one with the interest. So to the extent that in this case, the argument's being made, it would lead to absurd results. I don't believe that would be the case. We have, even this court is going to be hearing other cases this week on the docket where individuals were convicted of over a dozen counts related to a fairly quick subset of actions. And here, although multiple counts arose from this conduct, the sentencing guidelines and all the rules in place still prevent the state from pursuing, for instance, 6 consecutive sentences. It's not as though it will lead to an absurd sentence in Mr. Buchanan's case because of the guidelines prevent as much. When we look at other statutes and look for guidance on them, I believe it's pertinent to this court's analysis that this is a person offense. And that's why I'm asking this court to affirm Mr. Buchanan's 6 counts of aggravated arson. Recognizing I'm out of time, I'm happy to stand for any questions the court may have on that issue or the other 2 issues that were raised by the appellant. But absent questions, I'll remain tethered to the arguments made in my brief.
Thank you, Mr. Contest.
Thank you.
Grant, you reserve 3 minutes. That then the court will take this matter under advisement